All right, good morning, everybody. My name is David Fleischer. This is County Criminal Court at Law number 5. We are here with regards to cause number 2499983, State of Texas versus John Gerard O'Shaughnessy. Today is the day set for trial. Guys, would you please announce yourselves for the record?
Michael Haddad for the state.
Alex Macias for the state.
Savannah Luna for Mr. O'Shaughnessy.
Hey there, welcome to the Courtroom Files. So we're going to try something new for the channel with this video. We're going to take an entire trial that happened in Judge Fleischer's courtroom and we're going to break it down into kind of a what you need to know, highlights kind of thing, and cut out all the fluff. So this is a DUI case that was in front of Judge Fleischer. And we're going to start off with a hearing that happened before the trial began because it's interesting because it has to do with the defense's objection to the person who is heading up the prosecution. So it's an interesting place to start. Now, this is going to be different from other videos that we do on the channel, obviously, because we're going to go through a whole trial. So bear in mind that from time to time, we're going to cut in with some dialogue to kind of let you know what's going on, what to look for, and that sort of thing. But because this is new, also do us a favor, let us know in the comments what you think of the format and if we should do more of them. I just ask that you do us a favor and watch the entire video so you can give it a true judgment on what you think. Anyways, here we go.
The only other thing I would put on the record is I understand Mr. Macias is practicing under a supervised bar card, and he was gracious enough to send us that letter. Miss Luna was the same, and I looked up the rules about what they can do, and some judges didn't think she was able to do. It is from the state bar, and it says that you must be practicing under a supervised attorney, but they actually list Ryan Free. It says supervising attorneys, and it says Ryan Free. And that's the only attorney that the state bar lists can be supervising him.
It can be supervising Alex.
On his supervised status letter from the state bar.
He's another chief judge.
So we looked at this heavily. We had a long conversation with Judge Wright. There is a provision for remote, just to be completely candid, for remote supervision. And I actually called the state bar about that. And Miss Luna was in here trying to obtain a reset. I was across the hall, and they said there's no problem with that. If she can contact you by text, she can call you. It's not a hearing. So that was remote supervision. But for me to not sit with her during a trial, you can't remotely supervise them throughout the entire trial. They'd have to be on the phone with you the whole time.
So you're objecting to his presence then?
Yes.
So
I don't think it allows for him to try a case. Just going by the letter, it says specifically Ryan Free. It's the only attorney listed as the supervising attorney.
So Floyd, can you do me a favor? The statute that allows Alex to practice under a supervised attorney, does the wording state that as long as there is a supervising attorney, or is it only the person that signed their bar card?
Show me what you have so I can see it.
Yes, here.
It's not a statute. It's in the
Yes.
disciplinary
My
rules.
apologies. Yes.
I think it said the Harris County DA's office, have been.
And with respect to everyone here, and I don't mean to be rude,
Judges,
it also has to be someone that's been practicing for at least 3 years to supervise him.
Do you want me to email this to all the parties?
Yeah, or show me what you're referencing.
So what did you type to?
I typed in Texas student bar card and it says supervising bar card.
So then it might be that you might have to try the case, Mr. Haddad, and then Alex sits kind of, second chair with you. No, Tyler, you might have to try it against Mr. Haddad.
Alex is way too prepared, so. No,
Careful what you wish for, as they say.
I mean, I just think it's an issue that everybody should be aware of.
And I mean, if you're right, then you're right. I don't know. I've not seen the rule, and I didn't know what his actual status was until now, then you just said,
I didn't until last
So-
night either.
And so this is these are called the rules governing the supervised practice of law by qualified law students and qualified unlicensed law students, law school graduates in Texas. And then if you go to rule,
Alex, are you still in law school now?
Yes, Your Honor.
What year are you?
A third year.
and if you go to rule 4, it says, subject to the approval of the presiding judge, administrative officer, arbitrator, or other hearing officer, they can appear in any trial, hearing, arbitration, or proceeding on behalf of a client, provided the qualified law student or qualified unlicensed law school graduate has obtained the client's consent, notifies or has previously notified the court of the client's consent, and is accompanied, whether in person or by remote means, by the supervising attorney. And then if you go to rule,
But there's no client in this respect. Right?
yes, so, but,
I mean,
Yes.
this is,
and then the second part was about rule, I'm sorry, that was rule 6, and this is rule 7. I struggle with Roman
Do you have
numerals.
an email?
because, well, the spirit of that is with respect to if you're actually representing an individual person as opposed to the state.
Yes, Your Honor, I was just, if you go down to rule 7
Okay.
for supervising attorneys, the supervising attorney has to be an active member of the State Bar of Texas in good standing who has practiced law in Texas for at least 3 years. And so
Has he not practiced law?
I have no,
And
and
Your
that's what
Honor-
I was asking, if he, if-
How long have you been
No,
practicing?
2, Judge, but I'm reading some of the rule. One moment.
Yeah, and there's a duty to immediately notify the state bar membership department if the lawyer no longer meets those requirements of these rules.
Do you want to reach out to Beadle and see what he says real
Can you
quick?
give me one moment?
Of
Judge?
course, take your time. Just not too long because we get the jury, but yeah.
So how this ended up being decided was they went ahead and swapped around some people and got the person who is supposed to be overseeing this young man who is going to prosecute the case and get him to sit second chair for this trial. So that's how they ended up solving it. But it's important to note too that while we just showed you this one thing, there were actually several issues that the defense had with the preparations that the prosecution did, and they actually won most of the points. So it was a rough start for the prosecution for sure, but we used this one piece because we think it's important to note that we have a young, possibly fairly inexperienced person who is overseeing the prosecution of this defendant. Now, that's not, trying to slight him. We're sure he's good at what he does, but as this goes on, you'll see why that might be important. So let's go ahead now and jump into opening statements.
We're here today to talk about yesterday for a driving while intoxicated case. What we're really here is about a defendant who knew what the evidence would show from the very beginning. And what the evidence will show is what I'm going to tell you now. But before we do that, as I said yesterday, my burden is to prove each of those elements I showed you yesterday beyond a reasonable doubt. So I must prove to you that on or about March 7, 2024, the defendant operated a motor vehicle in a public place while intoxicated. All the elements I showed you yesterday beyond reasonable doubt. You will hear from an employee at a Sonic that the defendant drove that drive-through, struck the property, and asked for an alcoholic beverage. And it is through this interaction that the witness saw it necessary to call police. You will hear that the witness provided information to police that allowed them to locate the defendant and make contact with them. You'll hear that she provided information about his vehicle. You'll hear information that she provided information about the defendant himself. The other people you hear from are the officers themselves who followed up on that information. Those officers, utilizing the information they had from that witness, were able to go to the defendant's residence. And on their way to that residence, they observed the defendant pulling into his driveway. They observed the defendant exit the motor vehicle. And the officers will tell you that they made contact with him as he was walking towards the porch of his residence. And as he was doing so, you'll hear that he had a staggered gait, a walk to him that was slightly, unsteady. He had a poor balance as he was walking. The other thing you will hear from those officers is that when they made contact with the defendant, they noticed an odor of an alcoholic beverage, as well as his eyes were red, and he had a slurred speech. Following this, the officers saw it necessary to further investigate. You'll hear how they moved him in front of their vehicle to conduct standard testing, at which point the defendant refused to cooperate. The officers will tell you that at that point they took him under arrest, and they will tell you that they read him the statutory warnings required by law before they request a specimen of blood or breath. And again, they will tell you the defendant refused to provide any specimen. Because of that refusal, the officers will tell you that they continued up on their investigation and obtained a warrant to obtain information. And after you hear from those officers, you will hear not only from the technician that drew the blood from the defendant, you'll also hear from the analyst who actually did the laboratory analysis of the specimen provided. That analyst will tell you how she ran her analysis, how she received the sample to run her analysis, as well as she will tell you the results of that analysis. And she will walk us through the report that she generated following her analysis. You will also hear from the supervisor of that analyst who oversees the operations at the laboratory, and as well will be able to tell you guys the effects of alcohol on the body. She will also tell you how she oversaw the protocols of the report being generated to ensure they complied with the internal policies of the laboratory, as well as there were no evidentiary discrepancies when they made that report. Ultimately, it is, as I said, the evidence will show that the defendant knew from the very beginning exactly what you will see today. And at the end of this trial, I will ask you to find the defendant guilty of driving while intoxicated. Thank you.
Okay, so that was the prosecution's opening statements. Now, something I want you to note there is when he said at the very beginning, he emphasized that it's his burden to prove his case beyond a reasonable doubt. He also emphasized this the day prior when they did jury selection. And it's kind of an interesting thing for the prosecutor to point that out. I mean, I suppose it makes sense, but he especially makes a point of it more than others that we have seen. So he's making a point that he's got to do his job, so bear that in mind as we go on with the video, but let's see what the defense had to say in their opening remarks.
You're not going to like Mr. O'Shaughnessy from what you see very much in this case. This isn't a popularity contest. It's not. This is where the government has to give you enough credible, persuasive, and convincing evidence that it proves a person is guilty beyond a reasonable doubt. That they're trying to saddle Mr. O'Shaughnessy with a criminal conviction for the rest of his life. How much evidence does that take? It takes a lot. The reason I say you're not going to like him, you're not asked to be here today to put your green stamp of approval on everything that you see or hear. We know it's not illegal to drink alcohol and then operate a motor vehicle. You can't drive while intoxicated, and that's what they've got to to prove. So the reasons you're not gonna like some of the things that you see or hear, the one that, I think it's gonna be very interesting, on some of the discrepancies in this case. But they say that, Mr. O'Shaughnessy did go, so he has a thick Irish accent, Mr. O'Shaughnessy, you can tell by his last name. He goes through the Sonic drive-through, and they say that he hit the drive-through with his side mirror. And the person calls it in. And they do say, so you're not gonna like that part, that he supposedly runs into the drive-through with his side mirror. And then he does order a Miller Lite, and we don't know if he's serious or if he's joking, and he says something like, well, why not? This isn't a drink place. You're probably not gonna like that. That's not normal. I mean, that's not something you and I we might not do normally. Maybe you would. Maybe it's just a sense of humor. Regardless, we're not here on trial today for a person who damaged their mirror running into the drive-through, or a person ordering a Miller Lite from the Sonic. It's not against the law to go to a drive-through and say, can I have a Miller Lite? It also doesn't prove you're intoxicated. There are many different types of personalities in this world, and you will see that. But they've got to prove that those things were because he was intoxicated from alcohol and was driving his motor vehicle. Now, other things you're not going to like are when this is it's probably going to be a very short case. There's one video. It's not long, and it shows the officers at Mr. O'Shaughnessy's house. He's already at home on his private property and not driving. And they ask him to come over, and again, we all have different levels of patience or different temperaments. You'll see him start out agitated that he's being asked to, come over here, and then he outright he loses his temper, and he cusses at the officers. So you're going to see that. He says the F word to him. He tells them to F off. He's not on trial for being really angry about being in that position, getting arrested. I think there's a lot of people that would feel the same, especially if they didn't feel that they were doing anything wrong. You might know some people like this, but those are the things that you're going to see. Again, being really pissed off and angry at the officers, that doesn't prove a person was driving while intoxicated. But those are the things that you're going to see. So over here, though, is this is DWI. Those are all other things that they're going to try to use to say, we don't like him, we don't like what he did. But how do you prove DWI? And the evidence that you should see, that I'm not sure you're going to, I know you're not going to see certain things. There are three ways: a person not having their normal mental faculties, their normal physical faculties, or being a 0.08 or higher when they were driving. Well, I don't think you're going to hear about any BAC at all. Now, proving mental and physical faculties, that is done by using a series of standardized field sobriety tests. There's an eye test called the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. And by using these three tests, that's what officers are trained to do. You'll hear them testify to this. That's how they're supposed to determine who's impaired and who's not. You're not going to have any of that. There are no sobriety tests in this case either. You're going to hear he smelled like alcohol, and they thought he was intoxicated, so they arrested him. That's it. You're the judges of the facts. Not guilty means not proved. You're going to hear some evidence that you might not like, or obviously some evidence, because we're not here wasting your time, but it's not going to rise all the way up to beyond a reasonable doubt. All those ways to tell a person is intoxicated, you're not going to have in this case. Thank you.
Well, that's one way to do it. I guess the defense knows straight away that they have a defendant that is probably not overly likable, because they just ran headlong into the whole idea of you're not going to like this guy. So I guess if that's your weakness, just face it head on. Why not? But, you know, he makes some good points that there's some things that happened that didn't, in their minds, necessarily prove that he was driving while drunk. So we'll see how this plays out, won't we? So let's dig into the witnesses and see what's going on there.
Good morning, Ms. Castillo. Can you please state your name for the record? And how old are you?
20.
And why are we here today? What type of case are we dealing with today? Okay. And when or what month did the incident that we're dealing with occur?
In March.
And where did the incident occur?
Sonic Island, Deer Park.
Okay. If you could please wait until I ask another question to give another answer. Thank you. And what year did this incident occur?
2021.
Okay. And what county is Deer Park in?
Harris County.
Okay. And were you employed at the Sonic at the time of the incident?
Yes, sir.
And what were your responsibilities or duties at that Sonic?
Manage my son.
Okay. And would your responsibilities have included taking orders at the drive-thru?
Yes.
And was it in the drive-thru where this incident occurred?
Yes.
And was there a certain vehicle in the drive-thru that caught your attention?
Yes.
And could you describe this vehicle?
It was a light vehicle.
Okay. And what type of vehicle was it?
Like an SUV.
Could you describe the driver of the vehicle? I'll rephrase. Was there a male or female in the driver's seat?
There was a male.
A male, okay. Can you recognize that male in the courtroom today? Looking around?
No.
And Ms. Castillo, we did talk about it before. So,
Objection, that's leading.
Overruled. Continue.
could you, just to help jog your memory, what race was the male?
White.
And what approximate age, or could you describe the age of the male?
He was an older man.
Okay. With that in mind, would it be possible for you to look around and observe that male in the courtroom?
Objection, that's been asked and answered already, Judge.
Overruled.
I'll ask the question. With that in mind, could you observe the male in the courtroom? And could you point out the male? Could you point him out by indicating his location and indicating an article of clothing or what he's wearing?
Just say, don't, you,
Judge, I'm gonna object again. The witness had already asked if she could identify. She said no.
so if you cannot, just say I can't. It's really, just,
Ms. Castillo, have you testified before?
No.
Do you need a minute to compose yourself? Okay. Judge, we asked for a brief recess because she appears to be upset. Recess, a brief recess.
Sorry, I'm gonna object to that, Judge.
I'm not gonna, I mean, if someone needs a recess, I'm gonna allow a brief recess, but
We approach.
sure. Guys, remember, so ma'am, it's not just, it's either yes or no, okay? Okay. Okay, you may continue.
Yes, Judge. Ms. Castillo, based on your observations and your descriptions of the driver, would you be able to point out the male in the courtroom today and point out an article of clothing he's wearing?
No.
Okay.
Okay, so clearly the witness was not able to identify the defendant in the courtroom. Now, the prosecutor tried several different angles to get her to identify him, and it all failed. And we heavily edited this segment of testimony because there were so many long pauses as she was struggling to give him what he wanted, but just ultimately couldn't. As well, we are skipping the remainder of her testimony plus the cross-examination. It doesn't really add to the narrative here. This is the first big chink in the armor for the prosecution. Their witness, the one who called 911 to report him as a drunk driver, the one who should be able to identify him, was not able to. So that is a big problem for them. So let's move on to the next witness.
Good morning, Officer Fleischer.
Good morning.
Can you please state your name for the record?
My name is Officer Brooks Bosch.
And Officer Fleischer, what is your occupation?
I'm a police officer.
And are you a certified police officer in the state of Texas?
I am.
And how long have you worked with Deer Park as a police officer?
Currently almost 6 years.
So when you first began this investigation, what was the date of the offense?
Can I refer to my report?
Yes, officer.
The date of the offense was March 7th, 2024.
Okay. And was that investigation prompted by a call from dispatch?
Yes, it was.
And what information did dispatch provide?
Dispatch relayed that a couple, a male and a female, were driving a motor vehicle in the Sonic area. They had come to the drive-through and were trying to order alcohol through the drive-through and had struck a portion of the building with their vehicle. They also provided a license plate.
And was the call about a possible intoxicated driver?
The call initially came out as a possible intoxicated driver, but the caller was giving information regarding failed to stop and give information for a possible accident as well.
So, officer, what are the first steps in investigation when you receive this information from dispatch?
The first step was to run the license plate to see if we could figure out who the vehicle belonged to or where the vehicle's registered owner was.
And officer, what information did you obtain when you ran the license plate?
After running the license plate, I was able to determine that the owner was a defendant who I've come into contact with before. I additionally was able to observe the address of the registered owner.
I'm going to object just to relevance on what the officer just testified to.
Can you state your question?
Just what information did she obtain when she ran the license plate? And if you could continue, you were talking about the address. What information did you obtain when you were talking about the address?
Sure. I was able to observe the address of the defendant and noted it to be a place that I had been before.
Objection, Your Honor. May we approach?
Briefly, please.
Okay, so in the sidebar, the defense is objecting to the fact that this police officer disclosed that she'd had previous encounters with the defendant. They probably rightfully see that as a little bit inflammatory and not necessarily part of the trial. So they debate that, and here's what happens next.
Stephen, can you take the jury out for just 1 second and just hold them briefly outside, please? Madam Officer, my only concern is this case. I don't want you to get into anything about any kind of prior knowledge, prior context, anything of this nature, please. Anything, this case, it only resolves what you saw, what you encountered here, that's it. Okay?
I'd move for mistrial.
Okay, well, it's denied. You know, I don't think that it rises to the point where it's that kind of error that it would require mistrial. But like I said, if you'd like to, I could admonish the jury not to.
It would do more
you know.
damage to address it with the jury, so I'm not going to ask them.
But I mean, I'm gonna admonish you, if you get into stuff like that, I will. So no, anything about any kind of prior context, whatever, just, okay? All right.
You said you obtained the address, the registered address of the vehicle. Did you go to that address?
Yes.
As you're going to that address, did you observe a vehicle heading to that address?
Yes,
Did you observe the vehicle turn into the driveway?
yes,
Were you able to observe the driver exit the vehicle?
I was able to observe the driver at the driver's side door coming up, but I never saw anybody behind the wheel.
And officer, when you approached the address, was the vehicle still running?
No,
Was the vehicle turning off?
yes, the brake lights were still illuminated as if the vehicle was turning off and, you know, everything was shutting down.
Were you able to see the vehicle pull into the driveway?
Yes, I observed the vehicle pull into the driveway.
The driver, were you able to make contact with the driver?
I was,
Is the driver in the courtroom today?
yes,
Can you
Your
identify?
Honor, I object. That calls for speculation. The witness testified she never saw anybody behind the wheel.
Your Honor, she says she observed the driver, the person outside the driver's side, and she can state why she believes the person to be the driver.
No.
I can-
Did she see him driving?
And I can ask additional predicate questions.
See if you can, did she see that, who was driving?
That question has been asked exactly in that clear manner. And she stated, no, I never saw anybody behind the wheel. She said she saw a man out in the driveway and the car was off.
She didn't see him drive?
Officer, is it your opinion that the person you observed was driving?
Objection, that is leading and that calls for speculation. She's already answered that she did not see anybody driving.
Same.
Officer, did you form an opinion as to who the driver was?
yes,
And what was that opinion based on?
Objection, this calls for speculation, Your Honor.
How? How? Sure.
So you can see at this point the prosecution is really on their heels. This particular officer is now admitting that she did not see the defendant drive. So that's what the sidebar is all about, and you can see where the judge goes with it from here.
So let's go back, and I'd like you to ask her if she saw him driving, yes or no? Because isn't that the ultimate question? I mean, she can't say it right, and I want to make sure that that's what she said, right? If she can't, you can't change it, right? It's either you did or you didn't.
I know what you're trying to do, because she said she didn't see anybody driving, so I'm trying to ask you another question to fix that problem, because you have a big problem now. Nobody had their signs.
Please, let's not try this thing here, okay? Just Alex, ask her if she saw him driving. And that's it. Either she did or she didn't. I don't want to bootstrap. You either did or you didn't.
There anyone else in the vehicle when you observed it?
no, there was not.
And what was the time period between when the vehicle pulled in the driveway and when you observed the person outside the driver's side?
Seconds,
And did you confirm this was the same person the vehicle was registered to?
I did,
Did the person have the keys to the vehicle?
I don't remember,
And based on those observations, did you form an opinion as to who was driving?
I did,
And who was the driver of the vehicle?
Objection, that calls for speculation. She already said.
Sustained.
Thank you.
When you spoke to the driver, where did you make contact with the driver?
Objection, now this is objection to relevance now, because we've established she can't identify who the driver was. So any questions about what happened to the driver, she can't identify the driver. So I object to relevance. The question was, what did you do with the driver? She didn't identify, she didn't see this person driving.
She has laid the groundwork for circumstantial evidence as to how she formed her opinion as to who was the driver.
This is not a circumstantial game. It's not. And I'm sorry, Mr. Free, you know, do this. Let's take a brief recess. We're gonna take a brief recess. Let's take a restroom break. Ladies and gentlemen of the jury, I think we have a couple housekeeping issues that we have to get to. I'm gonna give you a brief recess. We'll try 20 minutes, I hope. I've got a lot of people as well, so bear with me. I'm gonna try to clean up as much as I can, and then I'll bring you back in here momentarily, okay?
All rise for the jury.
So bear with me, okay? Thanks.
So you'd probably agree at this point that the wheels have pretty much completely come off of the prosecution's case, and that's why the judge went ahead and recessed the jury. They're going to talk right now about how they're going to move forward, and the defense and the prosecution will both put up their cases for what they want to do. So let's have a listen to that.
You know, Alex.
Excused.
Yes, yes.
Okay, you know, the beauty about trial, also the most unnerving thing about trial, is you never know what kind of witness you're going to get. You know, when I tried cases before as a, you know, on the other side, there's two things. You never know how a witness is going to testify. Number one. Number two, you never know how juries will react, what's going to make them happy, what's going to piss them off. And it could be the most minute thing that you would never even think of that just really irks them in such a way that goes against you. So that's what I'm trying to tell you is you never know what kind of witness you're going to get. You know, even if you prep your witness, it's a completely different thing when you get on the stand, because if you've never been on the stand, I have before, because I had a defense lawyer put me on it to testify in a rule invocation problem. I was sweating bullets. I was nervous. I was a wreck. So as you can see, when she was testifying, it's tough. It's not an easy thing. So with that in mind, let's go on the record. I'm going on the record. You wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even they state that so they ran the license plate, and on a hunch, they went to, here's kind of the full story. She did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call. But then they go to his house, and
To his house?
they go straight to his house. They don't even go the direction the Sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the
hearing right now.
No.
She wrote that in the probable cause affidavit too, that she has encountered him before, and she knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Was there anyone in the vehicle when you approached? She said no. She said it was off. And then asked if he had keys to the vehicle. She said, I can't remember. no identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating or that was the truck, look for the damage on the mirror. They do
My
that.
only concern
There's no
now,
damage though.
concern now. Do we have a witness that sees him driving?
I mean, obviously, that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you, the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to
but you
driving.
can't get to the admission.
That's what I'm saying, is we've got to lay the groundwork there in order to get the officer, let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe, maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear that there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road. In the
There's
middle of
still a
nowhere, there's
hunch.
no one there.
It's a hunch. Sure.
She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house. Right. So she's going to, if given the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand
Didn't
that.
give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why
Judge,
the officers
just-
begin. I'm not. The Sonic is why
There
the
is no
officers begin
witness that can say
investigating.
they saw him driving.
You can't talk when he's talking. I can only take one.
Tyler,
I'm sorry.
let him finish.
Sonic is why the officers initially investigate the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving and that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why?
They recognize and they assume who that person is. There's 2 people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the wheel.
I don't
She's
think
not
it's
going to.
relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow.
Sorry.
I'll dismiss.
Yes, Your Honor.
All right. That's it.
So a motion to suppress the detention.
Thank you, Your Honor.
So there you have it. The state's case fell apart to the point where the attorney overseeing the young prosecutor just flat said, okay, I'll go ahead and dismiss. Crazy. I look back at this case and I wonder how it got to the point where both of their witnesses just completely flubbed it for them. What we don't know is how much of this case was put together by the young man trying it, and were there things he missed? Did the prosecution, did the state know that it was a weak case regardless, but wanted him to try it for practice or something? I have no idea. But ultimately, it just wasn't going to stand, and I'm frankly surprised it got as far as it did. But I think in the end, justice prevailed because, again, it is the the burden of the state, as the prosecutor said a couple of times. It is their burden to prove beyond a reasonable doubt, and they just flat failed in that. Now, I do want to take a second and give Judge Fleischer some credit, because at the beginning of that last clip there, if you paid any attention, you would have noticed that he was really trying to coach up that young prosecutor and let him know that this kind of stuff happens without just flat saying this kind of stuff happens. So that was nice to see. And all in all, I think the resolution for all parties was probably about as good as it was going to get. So let me know what you think of this case in the comments. Are you surprised that it fell apart like it did? Do you think it should have been brought in the first place? What do you think of the job that all of the attorneys did? How do you feel about how Judge Fleischer ruled in the end? Let me know those things. Also, if you've made it this far in the video, thank you so much. This is the longest one we've done so far with the channel. I would like to know what you think of this trial format, and if you'd like to see more of them. If not, I understand. Just let me know that too. Just please be kind to us if you'd be willing to do that. But we appreciate your time. If you did enjoy this and you want to have the fun continue, check out the video that is on your screen right now. And thank you for watching.